Modi. Just pause here. The defamation of the Honorable Prime Minister is not involved because he's not a complainant. Argue to say that it's a very strong case I have. It's a very strong. Your Lordship's test is prima facie case. Exceptional case. How do I make a prima facie case? Any case I make, your Lordship will then be told that if I opine upon it, then I'm opining. No. Your Lordship always says at the end, my opinion here is tentative only for purpose of 389. It doesn't mean I can't be convicted again. Doesn't mean I can't be acquitted again. But this paragraph unfortunately has that error, clear error. However, looking to prima facie evidence and observations in impugned judgment, it transpires that the appellant had made certain derogatory remarks against Honorable Prime Minister Shri Modi in general public, further compared the persons having Modi surname, thieves, and the complainant is also having the surname of Modi. Just pause here. The defamation of the Honorable Prime Minister is not involved because he's not a complainant. Certainly he's an identified person. The next sentence is the defamation. And further compared the persons having Modi's surname and the complainant is also having surname of Modi. That is 1 out of 13 crore people. It is that which is defamation. That can't be identifiable class. Moreover, now this moreover is completely unnecessary. It's completely surplusage, conjecture. It's irrelevant to the law of defamation we're discussing. Completely. This would be relevant if I said Mr. Purnesh Modi by name. It would be relevant. And he said, just I read page 39. He said, my name is not taken. The accused has not mentioned me. I am not identified. But yet, see the error. So there are two errors in para 5. The complaint is, moreover, the complainant is ex-minister and involved in public life, and such defamatory remarks have certainly harmed his reputation, would have certainly harmed his reputation and caused him pain and agony in society. This will apply equally the same degree of harm to Mr. Purnesh Modi, if this sentence is correct, will apply to each one of those 13 crore people. If that is so, then please accept it, but do not have sections like 499 and 199. Then you can't, the meaningless the section. The next point is, the somewhat serious facets of trial vitiation. And I'll highlight 4 or 5 immediately. Very serious. A separate one within those 4 or 5 is 202, which I'll come to separately. But what are those 4 or 5 matters of trial vitiation? Number 1. So I'll give 5 very clear ones. Or rather 4 maybe 4. And the 5th one is 202. Two of them are ex facie 2 plus 2 is equal to 5 errors. On the face of it. They are related. The two are related. What is it, The learned judge says he bases his sentence. He bases his case against me by saying that, look, Mr. Singhvi, you were warned or admonished by the Supreme Court in the Rafael case. And you had to be more careful. And therefore, because you were warned there, your error here today is more egregious. This is a direct finding at page 567, para 4. So this is the entire basis of sentence. Just see the 4th line, Further, in connection with the case of SLP so-and-so before the Honorable Supreme Court, I had appeared here, in the main matter. This is the Supreme Court matter. The accused had sought for the clemency in writing, and the Honorable Supreme Court had admonished him to remain alert in future. Though the accused has committed this offence, further, etc., if he is imposed lighter punishment, will set false example in society. Right, fellas? Now just note the 2 plus 2 is 5 error. This caution in the Raphael judgment, where the present accused was let off from contempt, is dated 26/11/19. Kindly note the date once.
14/11.
No. Order of Justice Gova is what?
14/11.
You said 26. You said. I'm sorry, a correction was 14/11. That is the judgment was of the Honorable Supreme Court, 14/11, not 26. It is common ground that the allegedly offending speech in today's case was made 7 months earlier on 13/4/19. Kindly note that date also. 13/4/19. Now, this is a clear error apparent because there is no question of being retrospectively careful. This speech in Kolar, Karnataka happened on 13/4/19. The admonition came 7 months later. So clearly, the learned judge misdirects himself. And it is at page 567. Note one more page, in the same volume, in my written submissions, I vehemently took this point of the error at page 671. I said this is a direct error. That's one part of the clear approach to the trial, approach to the sentence, the vitiating factors, why my confidence is shaken in the trial, in the conviction, in the sentence. The second related point is to this, that we are in criminal law. We are not doing some kind of a writ petition or just some affidavit filing. In criminal law, anything and everything, why does the Lordship go to such extent to say, prove the document, show the document, confront the person, put it to him? That's the whole system of criminal law. Sometimes you find it cumbersome, but that's the law. Biggest murder convictions are disturbed on these. Here, this entirety of the Supreme Court reference being the basis for sentencing. None of the Supreme Court, including the order or the record, was put to the accused. In particular, so, because it is admitted that the sentencing is done within 10 minutes on the same day. That is 23rd of March. Same day, shortly thereafter. As a matter of fact, had you put it to me, possibly the mistake would not have occurred. But that's a separate point. First point is, under criminal law, you cannot arrive at conclusions without A, verifying, you have to put the order, you have to, in fact, prove the order to be very clear, and then confront. None is done. That's point number 2. Point number 3 is more serious. And I raised this point again in my written submission in the appeal court. That is your Lordship's court below. This is the error by the magistrate. My learned friend has got the entire written submissions here, vehemently raised. The Sessions Court has ignored this point altogether, that you relied on a backdated event, not backdated, a prior event for a subsequent Supreme Court order. And then when I raised the point, the magistrate hasn't dealt with it correctly. The magistrate never gave me an opportunity to deal with it. You, the Sessions Court, should deal with it. The Sessions Court did not deal with it at all. Then, the third point is more serious. On the date when summoning order was issued, 2/5/19. Summoning order is 2/5/19. Your Lordship knows that the bedrock of all criminal proceedings is the summoning order, or most criminal proceedings. It's the trigger, it's the basis. On that day, when you look at a matter, because Lordship has 100 cases, don't set the criminal law in motion so easily, don't harass him. It's a tedious process, not just sending some summons in a civil matter. It has consequences, reputation, harassment, blah, blah, exemption seeking, presence in court, etc., bail sometimes. So all that wisdom, which your Lordships have said, be very careful in the summoning. Summoning order is the bedrock. Now, this was issued on 2/5/19. The point I'm making is that on 2/5/19, the Honorable Magistrate had no, I repeat, zero prosecutable evidence before him. Zero. There's no way he could issue summons, Malas. Why could he not issue summons, Malas? The bedrock of the bedrock. I said the summons is the bedrock, Malas. But the bedrock underlying the summons has to be, Malas, the speech. This whole case is about a speech. On that day, when summons was issued, there was no prosecutable evidence for 3 or 4 simple, obvious reasons. One, the person who complained was not the audience admitted. He did not say that I was sitting here and hearing Mr. Singhvi speak. 2, his whole case was, I'm talking about 2519, yes, that I, the complainant, received a WhatsApp which had an account of that speech, which is a newspaper report of that address. That's it. On the day of summons, the WhatsApp is not proved. WhatsApp in any case is hearsay. I get something on my WhatsApp, I can't prove it. I have to get the source which sends me the WhatsApp. The sender is not disclosed. Unidentified. Not known to the recipient, the complainant. Obviously, he has to be known. The only thing is he doesn't want to reveal his name, because how can I receive a WhatsApp without knowing who's sending it? No, something don't be very up like this. Now, Malas, there is on that day no pen drive. Nothing. It is hearsay upon hearsay upon hearsay on stilts, Malas, as they say. Shakespeare used the phrase, Malas, nonsense upon stilts. This is hearsay upon stilts. No YouTube, no pen drive. All that comes 2.5, 2 years later. We are not concerned with that. We are talking of the serious vitiation of the trial. How on earth can, Malas, a prosecutable situation arise for me to issue summons? It cannot. This is admitted. What is amazing is, turn to page 30 of Malas, Your Lordship's CC. I mean, what is worse is it is admitted. Nothing is left to the imagination. May I read it, Malas? 30. Middle. Bang in the middle, Malas. It is, may I read the previous sentence? I have not stated anything in my complaint about the fact of YouTube channel as stated in my deposition. You are issuing summons only on the complaint stage with some minor looking here and there. It is true that I was having WhatsApp message at that time of lodging complaint. It is true that I was not having disputed speech at the time of lodging complaint. But only message was received in WhatsApp. Then the magistrate can't issue summons. What's the point of the Lordship has got so many judgments saying, be careful, be hesitant. It is not true that it can be known after hearing the entire speech, whether any speech is defamatory or not. It is true that I cannot state as to how many persons wrote the speech at the place of speech and who gave the said write-up or recording.